Justice Gorsuch?
In fact, in Medina, we said the spending clause adds a layer to the 1983. And in terms of notice and consent, suppose a federal statute said something like this. If a coach at a federal funds receiving university allows biological men on a women's sports team, a female trying to make the team could sue for $1 million. Or an employee of a federal funding recipient in a state agency dealing with family affairs gets an abortion, the father can sue the employee for $1 million. I think on your theory, those are perfectly fine without any particular notice to the individual employee or any particular consent by the employee.
Maybe I can come back to one of the answers I gave before. The rule we're articulating has 4 ingredients. You need to have a valid condition that applies to the person. They need to be an officer within the scope, and then it needs to threaten the integrity of the program. I think under your hypotheticals, the real question is the first one. Can you actually attach the condition
Let's assume
to
you
that?
Can. Let's assume you can. Let's assume they're germane. And they might be germane, in terms of, for example, the student athlete might well be germane to a concern about discrimination against women that a federal funding program might well take into account under Title VI, for example, or the employee for the Health and Human Services. That might a pro-life Congress might well think that germane, and we might well find it so. So take as given that they're germane. I can come up with other examples if you want me.
I just want to be clear that this court's Dole test is already sort of addressing these concerns, right? So there's obviously the relatedness requirement, but then it also can't be coercive, and then you can't have an independent constitutional bar.
Suppose there's no constitutional problem with these.
And then if these people qualify as officers, which is not clear to me that they will.
Let's say they do.
Then it would then yes,
and it follows.
Because the answer would be. Sorry, hold on. Sorry, I think I missed one step. And then within the scope, which I think you have, and then it would need to threaten the integrity and proper operation of the program. And I think it is telling you that if, and this is the big if.
Mr. Tripp, where you're winding up is the spending clause is no different than the Commerce Clause.
I really don't think that's correct, Your Honor, because the crux, the most important condition on the Dole side is you can't have coercion, right? The state needs to go into it eyes wide open, and I believe in your hypotheticals, the person needs to take the job eyes wide open. And so those are very significant checks that mean this is never going to get to the same.
Both of those checks exist in my hypotheticals, and Congress could pass such laws. And that's quite a stretch of the spending clause. We've never before said anything like that.
I mean, if this court wants to cut back on some of the sort of frontline sort of scope, maybe you could do that in some future case, like in the hypotheticals.
I'm not talking about cutting back anything. I'm talking about what 9 circuits have uniformly done since RLUIPA's passage about 30 years ago.
Yeah, and I want to be clear that once Congress, and I'm not going to back down on this at all. Once Congress can impose the condition on the person.
I wouldn't expect you to, Mr. Tripp.
Once they can impose the condition within the scope of their work, and that can be that's a hard question, but here it's not. And once they can impose the condition, they can enforce it. I think that's the only step that we're asking about here. We're not asking you to change any law on the front end about what Congress can and cannot do in the first instance.